Welcome to the Texas Conflict Coach radio program. If you've ever experienced or engaged in destructive or unresolved conflict, then you know it leads to broken relationships, distrust, and damaging results. Our program will help you manage and resolve conflict effectively with strategies, valuable resources, and support. Since 2009, our radio program hosted guest experts from around the globe sharing their perspectives, experiences, and expertise while giving you food for thought. If you can't listen live, then download and listen to any of our 300-plus podcasts in our library at texasconflictcoach.com. So sit back, relax, or join the conversation every Tuesday evening, or tweet us at TXConflictCoach.
Hi, this is Zina Zumeta, your guest host for today's program. Our program today is Medical Errors and Medical Bills, Getting Your Needs Met Without Suing. If you experience medical malpractice, overbilling, or denial of insurance claim, what are your options? Who can help you? And how can you help yourself? Learn how to navigate the healthcare legal landscape. Joining me is Geoff Drucker. Geoff has addressed disputes from the perspective of a lawyer, mediator, designer of dispute resolution programs, teacher, and trainer. He wrote Resolving 21st Century Disputes, Best Practices for a Fast-Paced World, to fill key gaps he saw in our understanding of how disputes arise and get resolved. Geoff currently manages a healthcare dispute resolution program for the American Health Lawyers Association. Geoff is a returning guest at the Texas Conflict Coach Blog Talk radio program. He previously spoke about his book, Resolving 21st Century Disputes. Welcome to the program, Geoff.
It is a pleasure to be back, Zina. Thank you so much for having me and for taking on this important subject.
Well, thank you. So everyone knows that when there's a medical error, it's possible to sue the doctor or institution. All the ads that we see on TV from lawyers assure us that they can get justice for us. But I understand that you don't think that's necessarily the right approach. What approach would you suggest?
Well, to break that down into two parts, and the first thing I want to say is, the impression that you could easily get from the media is that having a medical malpractice committed to you would be just the ticket to wealth and happiness. But because of all the publicity you get about these huge awards, the truth is that it's very hard to win a medical malpractice suit in court. A typical personal injury case, there's latest statistics show about a 60% chance that the person suing, if they go to trial, would get a favorable verdict. In medical malpractice cases, that's 23%. So just a little bit over one-third the recovery, percentage of recoveries. Now, those recoveries do tend to be large, but they correlate with how severely injured the person is. So, yes, you could collect a lot of money, but only if you suffer a severe injury, a permanent disability. So it's not the way the media portrays it to be. And the best way to deal with the system is to not become the victim of medical malpractice in the first place. And that really is, yes. and there is something you can do about it. It's not the luck of the draw. And the key word is engagement. Right from the very beginning of the relationship with the healthcare system, for whatever it is, making sure that people understand what your symptoms are, what your goals and objectives are, making sure that you ask questions and that you get your questions answered to your satisfaction. And that's, when we talk about conflict in the healthcare system, conflict can play a very positive role in the system. It's very important for people to push back if they don't feel that their needs are getting met. Healthcare professionals are very often very, very busy. They've got lots of patients to serve. They've got lots of, they're being pulled in many different directions. And so they often don't give people right off the bat the time and attention that they deserve. You need to really make sure that you get that time and attention and make sure that people are responding to your symptoms and giving you the health care that you're looking for. And that may cause some friction in the system, but that type of conflict is good, and it can really help prevent medical errors. And that's very documented fact of the healthcare system, that the people who are more engaged get better health care.
So are you really saying that the squeaky wheel gets the grease?
You've summarized what I went on very, very succinctly, and that is true. What the healthcare system may sometimes call, the disruptive patients tend to be the ones who end up doing the best in the
Really?
system. Not being nasty, just simply making sure that, as I said, in a polite, respectful way, making sure that if you've got a symptom that you're concerned about, or there's something that's going on that you think maybe isn't right, then just checking in and asking the question or raising the concern. I'm a former cancer patient. I'm a leukemia survivor, so I have personal experience with this. There were along the way situations in which something wasn't going right, and fortunately my father was a doctor. In some case, he was the one who raised the questions, and then I learned to do that. So that's the use conflict, if I can use that word, in a positive way to get your needs met.
So are you saying that points, because I think all of us have kind of had points where we think, I'm not sure what's going on here, this isn't quite feeling right, and then we sort of go out the door, and you're saying don't go out the door, just stay there and ask the questions.
Yeah, and if you don't understand the answer the first time, say, I don't understand. Could you please try to explain it to me again? I'm really trying to get it. Particularly if you're being given discharge instructions and you don't understand them. It may seem polite, but those professionals, even if they're busy, even if they've got all other patients, they want you to succeed. They don't want you to walk out the door with a misunderstanding about your medication that's going to cause an error.
Wow. And I know that there's been a lot of publicity about the fact that people don't know what they're doing when they leave, and that a lot of those discharge instructions aren't followed for many, many reasons.
One of the biggest sources of errors in our healthcare system, and there are quite a few, is miscommunication or lack of communication. Sometimes that's between healthcare professionals, and sometimes it's between the healthcare professionals and the patients or their family members.
Mm-hmm. Makes sense to me. Well, can we talk a little bit about medical bills and what patients can do about them? I know that there's a lot of publicity these days about the fact that people don't know much about their medical bills and that they don't really understand them. Can you talk a little bit both about the uninsured and the insured patients and what we can do when we look at our medical bills and we have no idea what's in them?
Well, sure. The first thing is if you're the one paying the bill, then you have a right to an explanation. And the other part of it, which is often the case for people, is once they've got the explanation, they may not have the money to pay the bill. So we live in a society in which the vast majority of our purchases are non-negotiable. If you go to a developing country, there's a bazaar and everybody negotiates. People are used to it, but it's very hard in the supermarket checkout line or on Amazon.com to negotiate. Yes. So we're sort of out of practice, and hospitals will often be willing to work out some type of payment arrangement with people. Again, it's just as I said, they don't want you to fail in terms of your medical outcomes. They don't want you to go into bankruptcy and not be able to pay your bill. So they're often very willing to work out some compromise in terms of the price of the services, some type of a payment plan with people so that they can maybe not get 100% of what the bill is, but get something, and that you as the consumer can be able to stay afloat financially. So that's for people who are uninsured. is, call up the billing office at the hospital if you don't understand the bill, or if you're looking at it and saying, oh my God, how are we ever going to pay this thing, and find out what they can do and be willing to make some type of an offer. For people who are insured, and then the question is, well, is my insurance company paying what they should be paying? The most important advice I can offer is that the insurance companies have an appeals process. Each company has a somewhat different process, but they have them. And you need to make very sure that you find out what that process is and that you follow it as closely as you can. Because if you think, well, I'm just marching to court and I'll sue them because I'm so upset, the insurance company's defense is going to be, we have this appeals process. You didn't exhaust. That's the technical legal word. It's also what people often feel like they go through it. You didn't exhaust your remedies here, so you don't have the right to sue us. And so skipping that step or those steps isn't going to get you anywhere. And many times people are successful in that administrative process in getting the amount of reimbursement that they feel that they deserve. No system's going to give you 100% relief, but the insurance companies do take these seriously and try to be fair.
One of the questions that I have is I look at my bills, and a lot of times I have no idea what they're charging me for. How important is it for me to understand that?
Well, if your insurance company is reimbursing you 100%, it honestly isn't all that important. But if you have to pay a substantial part of that out of your pocket, yeah, it is. That's the insurance company's responsibility if they're the one paying the bill. Seriously. But if you're the one paying the whole bill, or a substantial part of it's coming out of your pocket, you need to understand. And again, that's where you might feel, I'm being pushy, I'm being assertive, maybe there's some friction here. The conflict's good. You have a right to know. You have a right to ask questions and get that answered.
And I think these days, we're all paying larger portions of those bills. So maybe it is going to get more important for us to figure out what they're charging us for.
Certainly.
Good point. So let me ask you, what if you actually have a situation with a medical error? What would you suggest in terms of people approaching that? So you really think something's gone wrong. You really think that the doctor or the nurse or whatever, they made a mistake. What do you do?
Well, if you are convinced that what they call in medicine an adverse outcome, which is something that wasn't expected or foreseen, is the result of a medical error, and the hospital or the doctor or the nursing home won't own up to it, then two options that you should definitely seriously consider are mediation and arbitration. Mediation is where a neutral third party helps the two sides in the case, or maybe more than two sides. It could be a doctor, a hospital, and the patient. See if they can reach an understanding about what happened and try to work out a settlement. In arbitration, the neutral is the decision maker. The neutral is basically like a private judge, except there's no appeal from the decision. So whatever that arbitrator decides, it generally is the end of the case. And the advantages, particularly in healthcare, in going to a mediation or arbitration, first of all, the process is private, so that we don't have to worry about having what can be very personal medical information aired in a public setting, like a courtroom. And the decision maker, the parties can agree on somebody who understands healthcare and understands medicine and how the healthcare is delivered. If it's involving a nursing home, can understand what nursing home practices are, how things are supposed to work, what things are supposed to not happen, and give a really informed decision, or in the case of mediation, it's not decision, but it's guidance. And this is a huge advantage because in a court with a judge or a jury, they often just, particularly as medicine's gotten so complicated, not able to really understand the situation. It takes a typical personal injury case, if it goes to trial, is 2 days. Medical malpractice case is 5 days in court, just to try to convey. So arbitration and mediation can be much faster processes. You've got somebody who's making the decision who really understands the situation. Again, it's private, and probably most important for many people is it's final. And what a lot of people need in those situations, they're dealing with the pain of having been the victim of medical error. They're dealing probably with additional costs, additional need for therapy, and having closure on the legal part of it. Whatever recovery they're going to get, just having it, not having to have this thing drag on in the court for years can be a huge, huge benefit from either one of those processes.
Now, before I have a couple more questions about that, but before I ask them, let me remind everyone that you are listening to the Texas Conflict Coach Blog Talk radio program, and we are talking with Geoff Drucker about medical errors and medical bills, getting your needs met without suing. So you were talking about mediation and arbitration. Can you give us a little bit of a picture of what that looks like? Who's there? How do you find this mediator? What kinds of people do that? And what is it that people are talking about in the mediation, and what are they presenting in the arbitration?
Sure. Well, let me take mediation first. And the way mediation is a voluntary process. So both sides have to agree that this is something that they want to do. And once they're in mediation, they're not required to do anything other than listen to what the other side has to say with an open mind, listen to whatever suggestions that the mediator might have about how to proceed, and decide of their own free will whether they want to continue in the process, whether they want to propose terms of settlement, and ultimately when they want to resolve. So you never lose control in the process unless you actually sign a settlement agreement voluntarily. And
now, who's actually there? Who are the cast of characters in the room?
That's a very good question, yeah. It can be done, what I call sort of the more traditional way is that the lawyers are really in control of the process. Sometimes the hospital will send only an official representative like the risk manager, not the physician or other healthcare professional who actually delivers the care. And sometimes the lawyer representing the complaining party, the injured party, will have the client not even have an opportunity to speak. And that's an unfortunate way to do it. It's often done that way because there can be a lot of benefit to both the healthcare professional and to the victim or their family members in having a dialogue, being able to reach an understanding about what happened. Often there's an opportunity for some type of an apology and forgiveness, and those intangible benefits can mean a tremendous amount to some people.
Yep.
But that requires that, obviously it requires the healthcare professional to be at the table, and it requires the lawyers to be willing to let that dialogue go forward. And there's been a lot of struggles in being able to have everybody be comfortable with having that kind of dialogue.
And I'm thinking that the patient may have as much trouble with that as well. They may prefer to have their lawyer do the talking and not have to speak to the healthcare professional.
Yes, everybody is different. So there are some who don't want to have that discussion, and there's some for whom that is extremely important. And I think that really the best lawyers who are doing this type of work now, if that's a dialogue that the healthcare professional and the victim want to have, is to be able to provide them with the coaching so that they are able to do this in a comfortable way. because the emotions can run very, very strong on both sides, both for the person who feels that they're the victim of medical error and for somebody who has devoted their life to providing medical care and has been accused of having done something that can be very, very emotionally devastating on the other side of the table as well.
Right. I remember somebody said to me once some years ago that all they wanted was to find out what happened. And they were told that they couldn't do that unless they sued. And they were just really upset about that. They just wanted that dialogue, exactly like you're talking about.
There really has been a shift, Gina, in it's not 100%, but it's a growing change within the American healthcare system to have the open disclosure so that right from the get-go when an adverse outcome occurs and somebody's obviously suspicious that maybe there was an error made, that they be given the information, opportunity to ask questions, have the direct dialogue. And that's the opposite of the way it's been done traditionally. The sort of old school system is called deny and defend. And that patient, all of a sudden, the instant that there's a risk of malpractice, is being seen as the enemy, and give them as little information as possible and deny that anything bad could have possibly happened. And the healthcare system is really getting away from that because it's not the humane thing to do, and it doesn't help to reduce errors in the system. Once you deny that an error occurred, you don't put a lot of energy into trying to make sure it doesn't happen again. So
good point.
The system is getting a lot better. It's slow. The change is gradual, but healthcare institutions are trending this way, and it's better for patients who because there are fewer errors in the system, and it's also better if an error does occur because it's getting addressed much more effectively.
Okay, that's wonderful. And you mentioned arbitration, and that arbitration is really more of a hearing, and that then the arbitrator issues an award. So why would somebody choose to go one way or the other, to mediation or arbitration?
Good question. And arbitration in healthcare has gotten something of a bad reputation in the media because there have been, unfortunately, some situations in which, and it's particularly nursing homes, had overreached and written agreements that were really one-sided in favor of the facility. And so some courts have overturned that. But those problems can be addressed. I'm very proud that the American Health Lawyers Association we're coming out with new rules for those type of disputes between patients and healthcare organizations that really strive for a very, very, very high level of transparency and fairness. And in fact, there was a case just came across my desk today where somebody whose family member had passed away in a nursing home decided to end the suit in court and bring it through our program instead. Why would somebody choose to do that? Well, if they look at the rules and they see that they're fair, then they're looking at a much faster process, and they're looking at a process that's going in which the person who is making the decision is a real expert. And those are two of the main advantages. And again, for many people, the privacy of the process and the speed of the process are also very, very positive. So again, it's unfortunate that there's been some abuse of the system, but when it works well, it's really better for everybody involved. If they can't resolve it by settling in mediation to get to a process that is fast, fair, and final.
So you might suggest trying mediation first, and then if that didn't work, then going to arbitration, and that the American Healthcare Lawyers Association, American Health Lawyers Association, has its own program, arbitration. Am I correct about that?
That is correct, and we have a national roster of people who are trained, and both for mediation and arbitration. It's very important to be good at the process, to understand how to be an effective mediator, to understand how to preside over arbitration, but also have that substantive knowledge. So we have people who are experts in all aspects of the healthcare system. Many of them are lawyers, and they're really more legal experts, but we have a number of physicians, nurses, healthcare administrators, and people with masters in public health, so people who have, in many cases, multiple degrees, just really understand all aspects of the healthcare system. And so whatever type of expertise is needed for the case, we can help bring that, recommending people to the parties who we think can make a knowledgeable, informed decision and provide a fair process.
Boy, that's great. And Geoff, you've talked also about lawyers and the role of lawyers in both processes, in both mediation and arbitration. What should people look for when they're going to an attorney?
Well, first of all, as you said, just as you need a neutral who really understands the system, you want to have a lawyer taking on this kind of case who understands what the medicine. They don't necessarily have to be a doctor, but there are many lawyers out there who have a great deal of knowledge about the medical issues that they deal with as an attorney. And so that's fairly first and foremost, is they need to have that expertise. And then secondly, I'd look at whether their goals and interests are really aligned with yours. Now, if people have suffered a medical error, they may have a huge financial need. They may have lost a lot of money. They may have a lot of medical bills to pay currently and for the future. And so they may look at it and say, money's what I need. That's my objective. I just have a great interest there. There are other people, as we talked about, who are also looking for other things. They're looking for that information. They really would like an apology. They'd like to know whether the hospital is going to institute procedures to help make sure that other people don't suffer the same kind of error. And if that's at least part of what you're looking for, then you should be asking your lawyer whether they're willing to work with you in coming up with a more creative type of settlement or approach to the case that really meets with what your needs are and what your goals are. And there are a variety of lawyers out there in terms of their orientation to these cases, in terms of their temperament. So look for that expertise, and then just also look, is this somebody that I can really relate to, who really gets who I am, what I'm looking for, and that I feel can really be a good advocate for me. And there's not just that there's a better lawyers and worse lawyers. It's just there can be the right lawyer for you.
And is there a listing of lawyers also in your organization? Is that a place to look?
We actually don't provide lists because we are a membership organization, so we can't favor one member over another. But local bar associations are a very good source of information. If you don't have somebody who can refer you to a lawyer, they do have lists. State bar associations may also have lists as well of lawyers who have healthcare expertise. So that is the best referral source in most places is either your local or state bar association.
Oh, that's great. Well, let me ask you, Geoff, listeners of this program know that we always ask our guests to talk about what would be the next step that they could take. And so can you give any suggestions as to if somebody has a problem like this or to avoid a problem, what should they do?
Well, a great step is to have a plan of action, such as a healthcare proxy, power of attorney, or advance directives, and make sure that your relatives know where those documents are, because when the time comes and there's some type of crisis, you may not be in a position to make decisions. And you want to talk about touchy conflicts in the healthcare system. When people aren't sure what somebody, particularly if it's an older person, they've got several children and they're not sure which one's in charge, and they've got different ideas about what you want or would have wanted if you could speak for yourself, that can cause a lot of very, very difficult conflict. So that's a great preventive step, is to review those documents with an attorney, get them drafted. It requires often a lot of thought on your part about what do I really want, and have them in place. And as I said, make sure that somebody knows where they are, has a copy or even the original, one of the originals, so that they can present it when they need to.
That's a good point. So I'm wondering if you have a final message that you could leave with our listeners.
Well, again, the most important thing to do is to make sure that you don't have an error, and that really comes, the best thing you can do is be proactive throughout the process and be engaging with people in a positive way, with the people who are providing care, with family members who are supporting you, and that requires often some good conflict resolution skills, being able to tell people when you're not satisfied, but do it in a way that shows that you respect them, you value their opinion, and you're just trying to make sure that you're all working together to achieve the best possible outcome.
Great advice. Well, thank you so much, Geoff. And if people want to find his webpage, he is at www.geoffdrucker.com, and that's spelled GeoffDrucker.com. And, of course, that's also on the website for this program. And, Geoff, thank you so much.
It was a pleasure, Zena. Thank you for having me on the show.
Thank you for listening to the Texas Conflict Coach. We hope you've enjoyed the program. You can find over 300 podcasts archived to listen at your own convenience at texasconflictcoach.com, or download the podcast at iTunes or Stitcher Radio. To learn about upcoming radio programs and resources, sign up for our monthly e-newsletter.